Hi friends! Welcome sa Part 9 ng ating NQESH o Principals Test Review 2022. Ngayong araw na to, i-discuss ko ang revised Rules of Procedure of the Department of Education in Administrative Cases. Ito ay stipulated sa DepEd Order No. 49, Series of 2006. Ang una kong i-discuss ay ang mga disciplining authority. Sa administrative cases sa Department of Education, meron tayong tatlong disciplining authority na siya rin ang magdi-decide sa mga administrative cases. Ang una ay ang DepEd Secretary na siyang magdi-decide sa mga administrative cases sa mga empleyado sa central office. Siya rin ang magdi-decide sa mga cases pagdating sa mga USEC, ASEC, Regional Director, Schools Division Superintendent at Assistant Schools Division Superintendent. Kalimitan sila yung mga nasa third level position. Ang Regional Director naman ang siyang deciding authority sa mga administrative cases na may kinalaman sa mga teachers at principal at public schools district supervisor. Kasama na rin dito yung mga education program supervisor na nasa mga division offices. Ang schools division superintendent naman ang deciding authority sa mga administrative cases ng mga non-teaching personnel within the division. So sila yung mga tatlong disciplining authority, DepEd Secretary, Regional Director, and Schools Division Superintendent. Kaya sa exam, pag tinanong kung sino ang magiging disciplining authority sa cases ng isang teacher, ang sagot dyan ay Regional Director. Pag naman isang non-teaching personnel, halimbawa sa inyong school, isang let's say ADAS, okay? Or isang administrative officer, ang magiging deciding authority kung sakasakali na siya ay magkakaroon ng administrative case ay ang Schools Division Superintendent. Ano-ano ba ang mga grounds for disciplinary action? Kalimitan, ito yung mga cases: dishonesty, oppression, neglect of duty, misconduct, disgraceful and immoral conduct. Kasama din dyan, being notoriously undesirable, discourtesy in the course of official duties, inefficiency and incompetence in the performance of official duties, or receiving for personal use of a fee, gift, or other valuable thing in the course of official duties or in connection therewith when such fee, gift, or other valuable thing is given by any person in the hope of expectation of receiving a favor or better treatment than that accorded other persons or committing acts punishable under the anti-graft laws. Conviction of a crime involving moral turpitude, improper or unauthorized solicitation of contributions from subordinate employees and by teachers or school officials from school children. Violation of existing civil service law and rules or reasonable office regulations. Falsification of official documents. Frequent unauthorized absences or tardiness in reporting for duty, loafing, or frequent unauthorized absences from duty during regular hours. Habitual drunkenness, gambling prohibited by law, refusal to perform official duty or render overtime service, disgraceful, immoral, or dishonest conduct prior to entering the service, physical or mental incapacity or disability due to immoral, vicious habits, Borrowing money by superior officers from subordinates or lending by subordinates to superior officers. Lending money at usurious rates of interest. Pursuit of private business vocation or profession without the permission required by the civil service rules and regulations. Insubordination. Engaging directly or indirectly in partisan political activities by one holding a non-political office, such as conduct prejudicial to the best interests of the service, lobbying for personal interest or gain in legislative halls or offices without authority, promoting the sale of tickets in behalf of private enterprises that are not intended for charitable or public welfare purposes, and even in the latter cases if there is no prior authority. Nepotism as defined in Section 59, Chapter 8, Subtitle A, Title I, Book 5 of Executive Order Number 292. Sexual harassment as defined and penalized under CSC Resolution Number 10940. Procedures in commencing administrative cases can commence in motu proprio or upon sworn written complaint of any other person. When we say motu proprio, this happens if there is obvious truth or merit in the allegations of the anonymous complaint or when there are evidences supporting the allegations. So when we say that a case is filed in motu proprio, ibig sabihin obvious na makikita ng disciplining authority na talagang malamang sa merong katotohanan at merong merit yung inirereklamo. At merong mga evidences na nagsasabi na talagang itong kasong ito ay karapat-dapat i-file. A grievance committee is not allowed to hear and decide administrative disciplinary cases. Why? Because grievance issues, on the other hand, are plainly work-related discontentment or dissatisfaction. So there is a big difference between administrative cases and grievance cases. So yung grievances ay work-related for discontentment or dissatisfaction. So there is a big difference. What are the forms of complaint? A complaint shall be under oath and shall be written in a clear, simple, and concise language so as to inform the person complained of about the nature and cause of accusation against him, to enable him to intelligently prepare his defense or answer. So we will be calling the person complained of usually in this discussion as the respondent. So what is the content of a complaint? A complaint should have the full name and address of the complainant, the full name and address of the person complained as well as his position and office in the Department of Education, a narration of the relevant and material facts which should show the acts or omissions as allegedly committed by the person. So this is the meat and the most important part of the complaint. So it should show the material facts and other evidences relative to the complaint. It should also contain certified true copies of documentary evidence and affidavits of his witnesses, if any, and certification or statement of non-forum shopping. Ano ba tong certificate of non-forum shopping? A certificate of non-forum shopping is a certification from a party attesting that he or she has not commenced any action or proceeding involving the same issue in the Supreme Court, the Court of Appeals, or any other tribunal or agency, that to the best of his or her knowledge, no such action or proceeding is pending in the Supreme Court, the Court of Appeals, or any tribunal or agency, and that if he or she should learn thereafter that a similar action or proceeding has been filed or is pending before these courts of tribunal or agency, he or she undertakes to report that a fact to the court or tribunal within 5 days therefrom. So, ibig sabihin, pag sinabing from the word shopping, ibig sabihin marami na pinagsampahan ng kaso. Ibig sabihin na nag-file siya aside from the administrative cases. Meron pa siyang ibang mga case na ipinail. So therefore, there should be a certificate of non-forum shopping. And that solely the case should be filed or administratively to DepEd. What are the actions on the complaint? Outright dismissal if there is obviously no truth or merit to the allegations. So once the DepEd secretary or the division superintendent or the regional director found that there is really no truth or merit to the allegation, then the case can be dismissed outrightly. Next, dismiss the complaint if the complaint is not in accordance with the required form and or if it does not comply with the required content of a complaint. So the complaint is not complete, there are lapses within the forms, so therefore it can be dismissed. If the complaint is sufficient in form and substance, the disciplining authority shall give due course to the complaint by appointing within 10 days from receipt of the complaint an investigator or investigators who shall conduct a fact-finding investigation or preliminary investigation. So if the disciplining authority found the complaint to be in compliance with the correct format and there is a motu proprio, and therefore there will be a fact-finding investigation committee, okay, who will be appointed 10 days from the receipt of the complaint. No action shall be taken on an anonymous complaint unless the disciplining authority decides to adopt the same and file it motu proprio. Again, we have here the word motu proprio. So, which means there is really a merit to the case. And there are evidences to point out that the respondent heavily weighs on being guilty of the complaint. So therefore, even the complaint is anonymous, then the complaint can be pushed through because it is filed in motu proprio. Within 5 days from the receipt of the appointment of an officers of DepEd as investigators issued by the disciplining authority, the designated investigator or investigator shall commence the fact-finding investigation or preliminary investigation. So it will commence 5 days from the receipt of the appointment. Usually there are the fact-finding investigation is composed of usually three persons. Sometimes it is composed of 3 principals, a public schools district supervisor, an ASDS, or a principal. It depends upon whom the disciplining authority will appoint. Or it can be a one-man team. Okay? The fact-finding investigation committee will issue an order to the person complained of to submit within 3 days from receipt of said order a counter affidavit. Failure to submit shall be considered as waiver thereof. So if the fact-finding committee receive their appointment, then they can ask the respondent to submit within 3 days a counter affidavit. And of course, failure to submit is considered to be a waiver for such a complaint. Upon receipt of the counter affidavit or comment under oath, the investigators may summon the parties to a conference where the investigators may propound clarificatory questions. The investigators may also interview any possible witnesses. So in the conduct of the fact-finding investigation, the committee will send notices to the parties involved. It will send a notice that there will be a fact-finding investigation and that they will be going to conduct an investigation, let's say in the office of the principal for both parties, and that they can also give notices to other persons involved in the cases or other witnesses for clarificatory questions. So if notices were given, then all the parties were informed. So during the investigation, minutes of the proceedings shall be signed by the parties and shall form part of the records of the case. So kalimitan, pag mayroong fact-finding investigation, yung respondent nagbibigay din ng statement, tapos may pirma rin yung statement niya, and then he or she can also give evidences to defend his part. On the other hand, the complaining party can also give their statement and also their evidences to proceed with the case. The investigator or investigator shall make an ex parte examination of records and documents submitted by both parties. Of course, the fact-finding investigation committee will study and connect the evidences, pointing out to the cases or the case involved. And they will give light using the evidences statement of the case. A fact-finding investigation or preliminary investigation shall commence not later than 5 days from receipt by the investigators of the order of the disciplining authority appointing him or them as investigators, and shall be terminated within 30 days thereof. So if the committee received an order to conduct a fact-finding investigation and after 30 days they have not yet conducted a fact-finding investigation, then that order will be terminated. Maybe the superintendent or the regional director or the DepEd secretary may appoint other persons to be the fact-finding investigation committee for such cases. The investigation report shall be submitted 5 days from the termination of the fact-finding investigation with the findings and recommendations. So after the investigation, the fact-finding investigation, the committee will submit a report to the disciplining authority 5 days from the termination of the fact-finding investigation. So minsan, kaya hindi agad na i-submit yung report kasi meron pang hinihingi na statement or evidences from both parties. Kaya there is at least a 5 days period to complete the report. If a prima facie case is established, a formal charge shall be issued by the disciplining authority. A prima facie case shall mean that there is a reasonable ground to believe that the respondent is probably guilty of the charge or charges against him and should be investigated accordingly. So pag sinabing merong prima facie, ibig sabihin merong reasonable ground, merong mabigat na weight, and usually the fact-finding investigation recommended for a formal charge, and that is there is really a prima facie case. But if usually the fact-finding investigation team recommended that the case will be dropped for lack of merit, then there is no prima facie case on that case. So actions on the complaint. So as I have mentioned, the formal charge contains a specification of the charges, a statement of material or relevant facts accompanied by certified true copies of documentary evidence. The respondent is directed to answer under oath the charge or charges in writing in not less than 72 hours from receipt thereof. The respondent answers whether he or she elects a formal investigation of the charges and receives a notice that he or she is entitled to be assisted by a counsel of his or her choice. So, pag na-receive niya na yung formal charge ng respondent, then he or she should answer at least not less than 72 hours, and therefore can also be assisted by a counsel. So, pwede siyang kumuha ng kanyang sariling abogado. The respondent shall be given the opportunity to submit additional evidences. So, if there are additional evidences, the respondent can also give such documents. So, the disciplining authority may issue an order of preventive suspension upon issuance of the formal charge immediately thereafter to any subordinate officer or employee if the charges involve the following: dishonesty, oppression, grave misconduct, neglect in the performance of duty, or if there are reasons to believe that the respondent is guilty of charges which would warrant his removal from the service. So usually, pag nagbigay ng preventive suspension, ito yung mga cases: dishonesty, oppression, and all others. And immediately after the issuance of the formal charge, a preventive suspension can be also issued. So within 5 days from receipt of the respondent's answer, the disciplining authority shall issue an order creating the formal investigating committee. So, nagkaroon na nga ng formal charge. Ang kasunod naman yan ay formal investigation. The formal investigation shall be held not earlier than 5 days nor later than 10 days from receipt of the order of the disciplining authority. Formal investigation shall be finished within 30 days. The investigation period may be extended by the disciplining authority in meritorious cases. So take note of the timeline. So after receiving the receipt of the answer of the respondent, 5 days for a formal charge, then the formal investigation shall be finished within 30 days. Within 15 days after the conclusion of the formal investigation, a report containing the findings and recommendations shall be submitted to the disciplining authority. So, review tayo. Kanina, nag-fact-finding investigation. So, nung nag-fact-finding investigation, let's say there is a prima facie case, and then it is recommended for a formal charge. Then, ang kasunod, ito na, formal investigation. Ang formal investigation naman, medyo matagal yung submission ng report. So, 15 days after the conclusion of the formal investigation, meron siyang report. As compared to a fact-finding investigation, the committee is given only 5 days. So, for formal investigation, ang committee ay binibigyan ng 15 days. The disciplining authority shall render his or her decision on the case within 30 days from the receipt of the report of the investigation. So once the disciplining authority, the regional director, the school's division superintendent receive the report, he or she can give a decision within 30 days. The party adversely affected by the decision may file a motion for reconsideration with the disciplining authority who render the same within 15 days from receipt thereof. So if a decision was made, both parties may file a motion for reconsideration. So pwedeng mag-file yung respondent, pwede ring mag-file yung nagrereklamo. And it can be filed to the disciplining authority concerned. Take note that only one motion for reconsideration shall be entertained. Administrative offenses with corresponding penalties are classified into grave, less grave, or light, depending on their gravity or depravity and effects on the government service. So, itong mga cases, pwedeng grave, less grave, or light. Ito yung mga offenses. So, the following are grave offenses with their corresponding penalties. So, dishonesty, first offense is dismissal. Gross neglect of duty, first offense is dismissal. Grave misconduct, first offense is dismissal. Being notoriously undesirable, first offense is dismissal. Conviction of a crime involving moral turpitude, first offense is also dismissal. So for other offenses involving light and other offenses, you may refer to page 17 to 23 of this DepEd order for the list of offenses and their corresponding penalties. And also on the comment section, I will be providing a link so that you can also download this DepEd order and also the PowerPoint presentation I have used. So thank you so much, and thank you for subscribing to Aris Barago Vlogs, and I promise to upload more videos and vlogs so that this will help you on the principal's test review, on the principal's test come March 2022. So again, good luck and God bless on your review. So continue praying that God will give you the wisdom to help you on this upcoming examination. Thank you, and hope that you are all well. Thank you for watching Aris Barago Vlogs. Watch, like, comment, share, and subscribe.